My name is Rebecca Zitlow. I'm the Associate Dean of Academic Affairs, and I'm really pleased to see all of you here today. I'm delighted to welcome you to today's Stranahan National Issues Forum lecture. This series began in 1990, supported by an endowment from the Stranahan family. The forum is a joint program between the University College of Law and the college's Federalist Society with the purpose of addressing issues of national importance through the lens of the American legal system. Over 40 of the nation's leading legal academics, economists, historians, political scientists, and public policy professionals have participated in the Stranahan National Issues Forum. To introduce today's speaker, it is my pleasure to turn to Lee Strang, the John W. Stepler Professor of Law and Values at the College of Law. Professor Strang came to the College of Law in 2008 after teaching at 2 other law schools. He is an accomplished teacher and scholar with publications far too numerous to mention here and speaking engagements. I mean, he's a nationally known speaker. He's speaking all the time, and we're very proud to have him on our faculty. Among his many duties, he is the faculty advisor to the College of Law Federalist Society chapter and coordinator of this lecture series. Professor Strang.
Thank you so much, Dean Zitlow. It's my pleasure to introduce today's Stranahan lecturer. Today's Stranahan lecture, like the lecture series more generally, provides a necessary contribution, a necessary perspective to our university's debate and discussion on important national issues. It's therefore my pleasure to introduce our lecturer, Professor Eric Claeys. Professor Claeys, a graduate of Princeton University and the University of Southern California Law School, is Professor of Law at George Mason University, Antonin Scalia Law School. After law school, Professor Claeys clerked in the Ninth Circuit Court of Appeals, and then for Chief Justice William Rehnquist. Professor Claeys then entered private practice at Kirkland & Ellis. Professor Claeys taught at St. Louis University School of Law prior to teaching at George Mason University. A member of the American Law Institute and a visiting professor both at Harvard Law School and Princeton University, Professor Claeys is a prolific scholar on a variety of subjects, including today's topic, natural rights to property. He's the author of over 50 articles, essays, and book chapters, and is finalizing the manuscript for his forthcoming book, Natural Property Rights. In his Stranahan lecture today, Professor Claeys will make the case for protecting private property as a natural right in American law and public policy. Natural rights, he will argue, set the measure for what governments should try to accomplish when they legislate on property, and they set the standard for saying whether particular government actions are legitimate or fundamentally unjust. Professor Claeys will speak for approximately 40 minutes, leaving 15 minutes for your questions and comments. Please join me in welcoming Professor Eric Claeys.
Give me a minute to handle the electronics at the podium. Can people hear me better than they did just a second ago? Good. Okay, and now I'm timing myself so you won't hear me for too long. Thank you very much to Professor Strang for inviting me to give this lecture, and thank you for his generous introduction just now. Thank you to Dean Ben Barros for whatever role he played in making this lecture happen. The Dean is an excellent property scholar and a very energetic and supportive administrator, and so I'm grateful for his help in making the Stranahan Lecture Series keep going forward with the interesting programs it's had. Thank you most of all to the Stranahan Foundation and the Stranahan family. I learned from Professor Strang that the Stranahan family is the inspiration behind it, the motivating force behind Champion, the Champion Company. And every spring, right about now, I put a Champion spark plug on my mower. And so this mower saves me the trouble of having to use a scythe or a thresher or something to cut all the grass in my lawn. And so it saves me a lot of time and a lot of, labor, so that I can do things that I find more enriching, like spend time with my kids and my wife. And a company like the Champion Company is producing things that help make people's lives better by saving them labor so they can do other enriching things. And in a system like that, then, when a company makes a valuable product and then uses that, people find that product helpful for their own lives, and then the profits from that company are used in part to support philanthropy like this lecture series. You have in miniature the example, I think, of a just society. You have different people, each pursuing their own life goals, some people producing things that help other people pursue their life goals. And as profits come out of that system, some of the profits are used to give back to support educational and philanthropic activities. And I'm honored to be part of a lecture series that embodies that understanding. And I hope to introduce today some ideas that carry forth or exhibit the kinds of ideas that the Stranahan Foundation wants to have be part of public discourse. So this lecture is the first salvo in putting into words ideas that are going to be in the book that Professor Strang mentioned. They're also going to be ideas in a shorter work, an essay I'm going to write for the Texas A&M Journal of Property Law. And that essay is going to be a 30-page introduction or sneak preview to the book. I expect that the essay in the Journal of Property Law will come out sometime next year, a little bit ahead of the book. So the real effective title of it is Why You Should Go Buy and Read My Book. But in I expect that the essay title will be Natural Rights and Property in Introduction. And I hope that that book chapter, I hope that the essay I'll write makes the book seem topical and accessible. And I hope that the introductory essay will go over some of the cases that first-year property students know and either love or hate. And I also hope to use in the essay a case that was just decided by the U.S. Court of Claims in December. And I'm going to talk a lot about that case in these remarks. In the book, I'm going to make heavy weather with property rights in oil and gas, how oil and gas mineral rights are unitized, and I'll rely a lot on property doctrines that are covered throughout a first-year property course, most often property rights that have to do with eminent domain and the rights that come into play when a local government condemns one person's or a neighborhood's property rights to make way for a developer who's going to bring growth. But again, for the essay I plan to write and the talk I'm about to give here, I'm going to focus on a case about oysters and about flooding of shoreline where there are oysters. And so in the talk I'm about to give, I think there are four main periods or parts of the talk. In the first, I'm going to introduce natural rights and talk about impressions by which natural rights seem spooky. And then in the second part of the talk, I want to suggest that natural rights maybe are not so spooky. And that will preview chapter 2 of the book, the chapter where I give an overview of natural law and natural rights and how natural law-based natural rights are structured. And in the third part of the talk, I want to introduce property and show how natural rights can inform reasoning about property in law. And here I'm going to introduce for the property student, or for the law students here, cases involving foxes and dispossessed Native Americans. And then finally, I want to then turn and talk about how natural rights can inform reasoning and policy about how property rights should be designed. And here I'll introduce another property law, first year chestnut, a case about ducks. But on to the first point, natural rights, are they spooky? And there are lots of reasons to think that they are. And if you doubt this, just look at news reports from back last Saturday. If you're like me, just 2 days ago, you weren't paying attention to the news because the Final Four was on. But yesterday, I was caught up on the news, and I noticed that there was a news article in a website called BizPac Review, and it was about a back and forth between Senator Ted Cruz and Judge Ketanji Brown Jackson, a nominee to the U.S. Supreme Court. Senator Cruz had asked in writing a series of questions to Judge Brown Jackson, and one of them asked, "Please explain in your own words the theory prevalent among members of the Founding Fathers' generation that humans possess natural rights that are inherent or inalienable." Responded the judge in writing, "The theory that humans possess inherent or inalienable rights is reflected in the Declaration of Independence, which states, 'We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness.'" And then Senator Cruz had a follow-up question. "Do you hold a position on whether individuals possess natural rights, yes or no?" Answered Judge Brown Jackson, "I do not hold a position on whether individuals possess natural rights." Now, only Judge Brown Jackson knows why she declined to answer the question. She declined to take a position. This observer thinks it's at least reasonable to suspect she was worried that natural rights are spooky and they might throw her confirmation off track. Now, if you doubt my suspicion, I can tell you stories about confirmation battles 30 and 35 years ago. 1987, then Judge Robert Bork was nominated to the U.S. Supreme Court, and a major part of the criticism of his nomination was that he was too hostile to principles of natural law and natural rights. Then in 1991, then Judge Clarence Thomas was nominated to the Supreme Court, and then Judge Thomas had written some articles that were quite sympathetic to the higher law and natural law traditions in American political and legal thought. And those writings were a basis for opposition to him. So if you say you're against natural rights, that can be disqualifying. If you say you're for natural rights, that too might be disqualifying. And I suspect that's what Judge Brown Jackson was trying to avoid. So then the question is, are these rights so spooky? Then one more episode, and this is the episode on which I'll focus the most later in this talk. So about oysters. So 2 days before Christmas last year, the U.S. Court of Claims for the federal government issued an order denying a motion under Federal Civil Procedure 12b-6. And a 12b-6 motion is a motion to dismiss a case for failure to state a claim on which relief could be granted. And this came out of a dispute between some oyster growers and the federal government. The U.S. Army Corps of Engineers helps a state-level river commission operate a spillway in Louisiana about 30 miles from New Orleans. The spillway controls floods in the river valley around the Mississippi River. In 2019, the Corps opened the spillway for more than 120 days. And when the Corps opened the spillway, it introduced trillions of gallons of fresh river water, and those gallons of fresh river water made their way down into coastal waters down along the New Orleans coast. Oysters grow in saltwater coast areas. And so when this fresh water that was released into the Mississippi River got down to the coastal areas where oysters are grown, the salinity levels in those coast waters dropped and oysters started dying. So 4 oyster growers, 2 individuals and 2 LLCs, brought a class action lawsuit. And it was a lawsuit for a taking. And the U.S. Army Corps of Engineers is an arm of the federal government. And so the theory was that the federal government, by discharging all this fresh water, was then damaging the oysters. The oysters were somehow property of the oyster growers, and the release of the water was a taking that needed to be compensated by just compensation. The issues got complicated in large part because the water beds where the oysters are grown, originally they belonged to the state of Louisiana, and the state of Louisiana leases these beds to oyster growers who then grow oysters. So the U.S. government made a motion saying the beds are public property, the oysters are wild animals, and they are public property too, and the oyster growers did not have property so that they could launch a taking suit against the federal government. And that led to 2 separate claims, there's 2 separate issues that I'm going to dwell on later in the talk. One is that the oyster growers have property in their oysters, so that when the Corps released trillions of gallons of fresh water into the Mississippi, the end result was to kill the property of the oyster growers. And the other argument is that that oyster growers, when they lease the water beds where they grow the oysters, the property in their leases entitles them to be free from certain kinds of interference. So the Court of Claims denied this motion, and the case was heard by, and the order was issued by Judge Ryan Holte. This may be of local interest. He was for a long time a professor at Akron's Law School, and he's still affiliated with that law school, but he's now a judge on the Court of Claims. And Judge Holte's opinion began, in his 1690 Second Treatise of Government, John Locke famously noted, "The labor of his body and the work of his hands, we may say, are properly his. Whatsoever he then removes out of the state of nature that hath, the state that nature hath provided, he hath mixed his labor with, and joined to it something that is own, and thereby makes it his property." So Judge Holte begins his opinion with a quote from Locke's 2 treatises of government, And the two treatises passages specifically arguing that there exists a right to labor, and the right to labor leads to a natural right to property. Now, that might have been seen as window dressing, after all, was the beginning of the opinion. But in Part 8 of the opinion, Judge Holthe started to look at the legal sources that might say whether the oyster growers had property rights. And in Part 8, Judge Holthe relied on Louisiana statutes. He consulted Louisiana law of property. He consulted federal takings law. But also, he quoted again sections 27, 123, and 222 of Locke's second treatise. So, for example, he cited from a dissenting opinion by Justice Thomas in a Fourth Amendment case, and Justice Thomas had quoted Locke's two treatises in his dissent. This is a passage. This is Justice Thomas. Once a government is formed, it cannot be given, and then Thomas starts quoting John Locke, a power to destroy that which everyone designs to secure, citing section 222 of the two treatises. And Judge Holthe concluded after that in a few other passages, there's a Lockean foundation of the Fifth Amendment takings clause, and he argued plaintiffs fix the water bottoms with culch, they acquire seed oysters, they place those seed oysters within their leases, cultivate the oysters, and then harvest the oysters. And then the judge continued, the plaintiff's backbreaking efforts, when mixed with the water bottoms, culch, and seed oysters, confirm the plaintiffs have quintessential Lockean property rights. So right then and there, a federal judge is citing passages of John Locke's two treatises on property and incorporating these arguments from Locke, these arguments about the natural right to property, and making those part of the legal argument why certain oyster growers might have viable takings claims against the U.S. government. Not a lot has been written about this opinion yet, but my general impression from talking with property colleagues and hearing about colleagues who swap stories on Facebook and Instagram and other social media accounts is that property scholars were a bit surprised. They thought it a bit unusual for a federal judge to be citing Locke. And the surprise must be because property or natural rights somehow seem spooky. So that then sets up the next 3 points in my talk, or the next 3 issues in my talk. Again, the second movement in my talk I'll ask, is natural rights talk spooky? And then in the third part I'll ask, assuming there exist natural rights, are they ever directly relevant in legal reasoning? And if so, how? And then finally I'll ask, are natural rights ever relevant to structuring legal rights? So, but on to the second part, are natural rights so spooky? And here, for those interested in the book, which I encourage you to buy when I finish writing it, this will be a preview of chapter 2 of the book, Natural Law, Natural Rights, and Perfectionism. So the way to, are natural rights so spooky? And I think that you could reasonably turn the question around and say, why wouldn't they be reasonable rights to think about? And the way to think about this is just to think about some right that's an uncontroversial moral right. And in the American legal and political tradition, the best place to go is probably to Brown versus Board of Ed. So imagine there's a state policy that says that people who want access to certain facilities of the state, the people can be segregated on the basis of race. So there's a state law saying that people are entitled to access to state benefits, but the benefits differ depending on the race of the person. And most people are going to have, and all reasonably well socialized people are going to say, that's just wrong. And if somebody were to say back, yeah, but there's a state law saying that this is an acceptable policy, so why shouldn't morality follow what the state says? The answer back will be, no, there are some entitlements that people have just by being people, and people are entitled to be respected in certain ways and treated in certain ways. And if a state policy distributes benefits and one's racial background has nothing to do with the benefit, then it's just wrong to discriminate in the provision of the benefit. And this insistence that it's just wrong is an appeal to standards of objective morality that say what rights people have. And that's an appeal to natural rights that are structured consistent with principles of natural law. And once one conceives the force of an example like that, now the door's open. We can argue about what natural rights are and what principles of natural rights are, and we can argue what they cover and how they apply in different topics. but there at least, everybody at that point now agrees or recognizes that natural rights are entitlements that people have as a matter of natural morality. And so then the next question then comes to be, if these natural rights exist, how do they affect, how do we work out what they are, and how do we reason about them? And here, this is a preview of chapter 3 of the book called Property and Practical Reasoning. And I want to I could stipulate this and take questions on it if people have them. Natural rights, in a few applications, they apply in a narrow and deep way. In more applications, they apply in a broad and shallow way. When are they narrow and deep? If one person is trying to perform an action that's intentionally trying to deny someone else's natural right, there are prohibitions against doing that. One can't intend to kill somebody else. One mustn't intend to take someone's property. One mustn't intend to make a false statement intending to mess with someone else's reputation. And there are other prohibitions like this. Much more often, however, natural rights set standards. And in a lot of ordinary situations, people go into society trying to do things that are morally productive. But they don't, when they're doing what they think is productive, they're not always sufficiently considerate of the natural rights of others. So think about the reasoning that goes into a speed limit. Legal philosophers like to talk about speed limits, maybe to the point that legal philosophers beat the image of a speed limit to death, but it's a homey and effective example to illustrate the point. So when people drive, they're thinking, I want to get somewhere. And there are morally productive things at the ends of every driver's destination: to see family, to go to work where the person's going to perform valuable work, to do something recreational, and there's value in play and enjoying aesthetic experiences. But people might not think sufficiently about the way driving affects other people's rights. So somebody who's driving is exercising a natural right of liberty. If we want to be more specific about it, is exercising a natural right to travel. But if one travels in a manner that's not sufficiently considerate of others' rights, one might crash and hit somebody else and jeopardize their natural right to life, or crash their car and thereby damage the property rights that are protecting their natural right to property and security and property. And so then there then comes to be a need for some legislative institution that coordinates how drivers drive respectful of the natural rights of other drivers and other passengers on the road. And then so a legislator who's trying to set these speed limits then has to ask, how are people driving? Where are they driving? What land uses are nearby the roads where the driving is taking place? How many cars? And all of these questions sound like fact-intensive questions, but the questions are being asked because they're all questions that fall out of the insights that there are people on these roads who want to travel, and some people on these roads who might be jeopardized. And there's some people who live next to these roads who are doing things on the land next to the roads. And we're trying to figure out how to let the drivers drive in a way respectful of the rights to liberty, but in a manner that's also respectful of the rights to personal safety, the rights to property of the people next door. And so natural rights set mental images or standards for legislators to think about when they're trying to reconcile conflicting natural rights. So, and now in this regime, natural rights supply a moral foundation for laws. And they give general guidance what the laws ought to look like. But they don't provide specific limits. And so this is one of the reasons the speed limit example is so powerful. Montana speed limits differ very much from speed limits up and down the eastern seaboard. And that reflects the fact that roads in Montana tend to have fewer people on the wayside than roads in the northeast. And those kinds of differences in speed limits might also trace back to the fact that in different communities, there's different expectations about how fast is too fast or how fast is reckless. And a good system of laws is designed not only to reconcile the rights, but to do so in a manner respectful of local opinions and differences in local opinion. So then, how might natural rights guide legal reasoning? And again, this is more of a preview of chapter 3 of the book. And so the way I want to ask this is to go back to Judge Holtby's his opinion in the Campo case. And so Judge Holtby, again, he invoked John Locke, Two Treatises of Government, twice. And the concrete way to ask this question, how do natural rights guide legal reasoning, is to ask, did Judge Holtby go over the line? Now on this, I don't yet have a final answer. I doubt that he needed Locke to support the opinion and the judgment, or the order that he handed down. But I also don't think it was out of court for him to rely on Locke, and I want to explain why. And make it, if it's not clear, this is the point at which the tension between Senator Cruz and Judge Brown Jackson is now kind of coming back. If a legislator wants to know when a judge is, and why a judge might, if a legislator wants to know whether a judge is going to believe that there exist natural rights, the legislature might be wondering, will this judge invoke natural rights as a controlling legal authority in some case? And if so, the legislature might want to know when and why. And the basic account I want to give goes something like this. Natural rights can be relevant in a narrow range of disputes. And those are disputes in which there's no positive law on point, and there's no positive law saying it's impermissible or illegal to bring natural rights principles into discussion. And if that answer sounds like a dodge, let me explain it a little bit. And I'd like to explain it in reference to the two cases that first-year property students read most often at the beginning of a course. One is the Fox case, and the other is the dispossessed Native American case. So the Fox case is Pearson versus Post. In this case, Post was hunting fox with some friends. He got into hot pursuit of a fox, and he was chasing the fox on a public beach, and he claimed he was close to catching it. And then at the last minute, Pearson came along, found a stick, clubbed the fox's head and killed the fox, and then walked off with the pelt. And Post sued Pearson, saying, you took a fox that I had effectively caught because I was in hot pursuit of it. Now, that case is introduced in the first-year property course because it raises the basic question, if there's something that's not yet owned, how and why in law and of property does an unknown thing come to be owned? But it's also a wonderful introduction to legal reasoning. And when I teach Pearson first, I start with the legal reasoning and the jurisprudence behind it. It's because the majority opinion ends up citing Justinian's Institute's international law treatises by Pufendorf and Grotius and Locke. And so the case is relying on sources of customary international law, and those sources of customary international law are basically natural law treatises, and it's also citing Locke, and Locke was a natural law political treatise. And so the question is, why was it fair game for the judges in the Pearson case to be going to legal treatises that are applying straight away natural law? And the answer has to understand the answer, you have to let's go through a hierarchy of legal reasoning. The first place you'd look as a New York lawyer, Pearson was decided in New York, to find out whether Pearson or Post first got the fox is you go to New York statutes. But Pearson was decided in 1805, and in the 29 years since the American Revolution, and in the 23 years since the peace treaty that confirmed the United States were independent, New York's legislature, in its wisdom, had not passed a statute about foxes or other game. And so then the court then went to New York common law, but the New York common law in that same period hadn't issued any opinions about catching game. So then, since New York had been a colony of England, the court wanted to look at English law. And there were some English cases that seemed on point, but those were decided under the authority of statutes enacted by Parliament. And statutes enacted by Parliament never had controlling effect in New York because the New York's colonial legislature and then the New York state legislature wrote the statutes that bound New York subjects and then citizens. And then there were other common law cases out of England, but those cases, they talked about game, but they talked about game in a context in which game was being caught by a chaser or a hunter on another person's private land. And those are distinguishable because the fox in Pearson was caught on a beach. So the takeaway from all that is the court was willing to look at positive law of two kinds, statutes and common law. But since there were no statutes and no common law, the court was left to consult the basic principles of the common law of property. And where did the court find the persuasive authorities on the common law of property? The answer was and the treatises of customary international law by Justinian, Pufendorf, Grotius, and a few others, and then also Locke writing about property. So then the takeaway for Judge Holtby is one ought to look to see whether there's any, one can look to see whether there's any controlling Louisiana federal law about this takings dispute, and if not, then okay to rely on rely on Locke and other natural law sources. But that all works within limits, and those limits kick in if a community's already made clear it doesn't want to hear about natural law. And the most famous example in the American legal tradition would be the treatment of slavery before the 13th Amendment. And there are many people who subscribe to principles of natural law, and they thought that as a matter of natural law, slavery was against the natural law, but they recognized that if a state had instituted slavery, had it instituted positive law inconsistent with the natural law, and the positive law deserved respect. In property law, people learned that principle in a case called Johnson and McIntosh. Johnson and Graham had acquired land in what's now Illinois from, they were successors in interest of title that had been passed on originally by two Native American tribes. McIntosh had gotten title from the U.S. government, and McIntosh argued that the titles that had come from the tribes were not good titles because the tribes had never had the power to assign away land. And to make that argument, McIntosh argued that European countries that had colonized North America had all agreed among themselves that Native Americans could occupy land, but they could not acquire legal title. And the only entities capable of granting legal title were the countries of the Western European countries that had colonized these areas. And Chief Justice Marshall, in a unanimous opinion for the Supreme Court, agreed with McIntosh's argument. And from Chief Justice Marshall's opinion, as the right of society to prescribe those rules by which property may be acquired and preserved is not and cannot be drawn into question, as the title of lands is and must be admitted to depend entirely on the law of nation in which they lie. It will be necessary in pursuing this inquiry to examine not singly those principles of abstract justice, translation, principles of natural law, but those principles which our own government has adopted in the particular case and given us as the rule for decision, translation, the positive law. And Marshall and his brethren agreed that the positive law made very clear that Native American tribes did not have authority to pass on title. That was a perquisite given only to England and to France and then to the United States. So then for Campo, what you need then is some kind of indication that the U.S. or Louisiana or both had said that natural rights principles associated with property are not fair game for a judge to apply because the U.S. or Louisiana law had made clear natural rights of property are not part of the decisional law on the topics that the court had to deal with. Now, what I want to suggest that when one looks at the facts of Campo, I don't think there's a clear answer to this. I think that it's okay to recite principles of natural law, but I don't think it's flat out required. I think that there's two lines of legal issues that have to be run down before the Campo's case is finally litigated to a satisfying judgment. And one is to ask whether when an oyster grower puts an oyster on the bottom of a waterbed and grows it, can he acquire property in this oyster that he's grown in a way that's kind of analogous to the way a farmer grows a crop or some other plant? And then the separate issue to run through is to ask if an oyster grower has leased a waterbed, if someone floods that waterbed in a way that disrupts the uses he's making of the leased waterbed, has there been a disruption of his property rights? And there are provisions in Louisiana statutory law on both of those points. So there's a Louisiana statute that says that oysters are public property. Specifically, Louisiana statute annotated section 56.3 says that the ownership and title to all beds and bottoms of rivers are and remain the property of the state, and it specifically includes oysters and other shellfish. So that seems to say that the oyster growers cannot have property in the oysters. But maybe they can if it's an oyster they planted there and was originally theirs and they planted. That's a hard issue. You'd have to run that down in Louisiana decisional law. But there's also a statute in Louisiana saying, a lessee shall enjoy the exclusive use of the water bottoms leased and all oysters and culture growth replaced thereon. So that statute tends to lend support to the idea that like an oyster grower has property in the lease rights for the waterbed, and if something happens to disrupt the uses he's making of the leased waterbed, then he's got a serious takings claim. And one would have to run those two theories to ground. If there's law on both of those points in Louisiana decisional law, you can use that and only that to decide the Campo case. If there's not decisional law to that effect, then you have to go somewhere else. You'd have to go to the first principles of property, and at that point you're going to principles that are not that different from, I think they're operationally the same as the natural rights principles that the Pearson court relied on in Pearson versus Post. So then finally, the last topic I want to cover, so if natural rights assuming that natural rights are somehow germane to this reasoning about the issues in Campo, can natural rights ever provide guidance about the design of the legal property rights that are also at issue in Campo? And on this, I'm going to come at the questions looking at things from the perspective of a moral philosopher more than a lawyer. So assume that there are property rights in the leased waterbeds, and maybe in some circumstances a private oyster grower can acquire private property in an oyster. Why are those just rights? And this here is a preview of the back part, the longer part of the book. And so I'll go through, and there's a series of questions that have to be answered on policy grounds. And in the book, I'm going to argue that all of these policy questions can be informed in a helpful way by natural rights reasoning. Question 1, why are oysters and why are lease rights in land or other realty, why are they property rights at all? And the answer is property rights need to be distinguished from rights that arise out of people's persons, like a right of personal bodily integrity, a right of reputation, freedom of contract. And that's because everybody in a community deserves equal opportunity to acquire some resources that are not people. And so the legal rules you have for the resources that are not people have to be structured in a way so that the people with the rights have security that these things that are not the extensions of themselves are theirs. And people who are not going to have access to the same resources get clear notice, I need to stay away from this already owned resource. Next question. So why would it be just to institute property rights at all in these resources that are not people? And that's chapter 5 of the book, and this goes through the basic grounds for acquiring a natural property right, relying a lot on Locke's chapter 5 of the second treatise. And the argument here goes, if there's a resource that's not yet been used by anybody, and one person starts using it productively, that use is a valuable activity, and the person deserves a right not to be interfered with while engaging in the valuable activity. Now, the condition for getting this right is that the person needs to give fair notice to other people. They need to find some other resource to start using in valuable ways for their own life goals. And so there's a duty to use productively that generates a property right, but it's conditioned on a responsibility to communicate claims of your property rights to others. And then there are other follow-on limitations if there's not enough to go around, Locke's enough and as good proviso, and another limitation for cases of emergency or necessity. But let's stipulate that the oyster farmers are not denying other people equal opportunity to get oysters, and if anything, they're enhancing the supply of oysters by growing them and circulating them for others. So then the next question is, why might there be a property in a lease? And to answer that, chapter 6 goes through the topic of what is a property right. Property rights are not just rights of full ownership over an oyster, over fee simple absolute of land. Easements, mortgages, and leases are all property rights too. And chapter 6 describes the bare minimum that a legal right needs to have in order to be a property right. And the right to own an oyster and the right to have a lease are both over that minimum. So then the next three questions are, when exactly do the principles that justify private property, when do they justify private property in an oyster or in the lease and the right to grow oysters on the lease? And they're very difficult design questions about private property. The principles that justify private property can also justify in some circumstances public commonses. And so they can justify like having oysters and water bodies be public property. And so chapters 7, 8, and 9 run through why the principles that justify a natural right to property, why they justify private property as opposed to public commonses, and then how private property gets packaged so a right to the lease of a waterbed entitles someone to the right to use the waterbed to grow oysters and get the benefits from growing the oysters. And then another question to ask is that, so if there's property in a waterbed, how can you split that into a lease and a future interest? Chapter 10 will take that on, talking about how full ownership rights can be split apart. And then another question you need to ask is when is it that activity by a neighbor disrupts someone's property right? In the Campo case, when is it that discharges of water by the government is tantamount to a private nuisance on a private lessor's land or waterbeds? Chapter 12 on property and private law takes that on. And then the last question you'd have to ask is when it is that the government does things to disrupt property rights that requires the taking, in chapters 13 and 14 will take that on. So I hope those overviews interest you in the book. I also hope that they show you that principles of natural rights, they can, in some narrow situations, provide rules of decision, but in other situations, they provide justification for having a system of property law that identifies resources as the object of property rights, gives the standards for making them private property, gives information about how the property right should be designed, and then gives standards saying when governments and private actors inappropriately interfere with other people's property rights. And those are the things a satisfying normative theory needs to do to give lawyers and judges effective guidance. And with that, I thank you for your time, and I'm happy to take questions.
We have a microphone going around.
Hello, my name is Noah Woods. I'm a 1L here, and I was curious to kind of go off those questions that you ended on. Something that you had mentioned about the value of the activity and that kind of inuring property right to it. I was curious how would you define valuable? So just as some background to my question is, I know in this oyster case, the reason for the letting of the freshwater out was to help prevent coastal erosion, and it was kind of determined that that is a very valuable goal because of the economic cost that erosion causes. So what is your thesis for saying that this abstract property right to profit from oyster farming, because as I understand it, didn't necessarily eliminate completely the ability to harvest oysters, just the potential for profits to be made because it reduces the viability for oyster farming. So how is it that that value is more important, and how do you weigh that value versus the more general public value in all of our natural rights to preserving our coastal lands and waterways and all the external benefits that flow from that?
Thank you. That's a wonderful question, and there was material on the cutting room floor of the last draft of my talk that covered this. So I don't know whether to be sorry that I didn't put that in, or grateful to you ask the questions. I can bring it back in. So, in the account of natural rights I'm giving, in it, natural rights can be understood as natural rights theories can fall out or be described in two families. In one, natural rights are justified by their tendency to establish and respect freedom, autonomy. In another, natural rights are rights to do things that are valuable and are morally valuable. And so the right has to be earned or shown to produce value. The theory I'm introducing in the book is in the latter family. And so there's some questions about value that you're hitting at that are entirely reasonable to ask. And I apologize if it takes me a couple of steps to go through to answer the question, but it's a series of moral presumptions that then get turned into legal presumptions. The first thing you ask is somebody engaging in an activity that seems likely to help the actor or someone else survive or thrive? And in rights-based theories that rely on these ideas about moral value, you say, in a complex world with a lot of different people, every person in the community is going to be presumptively a bad judge of what other people do with their own things. So think of the story in the Bible where Solomon has the two women come before him saying, "It's my baby, it's my baby." Now, Solomon was a very wise king and could figure out whose baby was whose, but he had divine help. And so we should be mistrustful that a legislator, a judge, or a regulator is going to be able to say, one person saying, "I should use that because I can put it to a high value use," and someone else says, "I should use it because I can put it to a high use." We want a system where judges, regulators, and lawmakers do not make those kinds of judgments. And so the way to do so is then to say, let's create a set of rules that abstract from the particular uses that people are going to make of things or the particular activities people are going to engage in, and instead focus on criteria that seem to prioritize appropriately. So then you've got the oyster growers might say things like, like nobody here is using this waterbed. We are using it to grow oysters. We can sell the oysters, and the money we'll make will help us do things in our own lives. The oysters that our consumers buy from us, they can eat, and they survive from doing so. There's moral value in all this. And as long as no one else has yet started using that oyster bed, and as long as the growers mark it off that they're using this bed, that's enough to signal to others, if you can do other valuable things, but you have to find other resources to do so. And if these people have already established a right, and these growers have already established a right in this water line or waterbed, then maybe you can convince us that you have, like, it's absolutely necessary you have that bed, but there's going to be a very, very strong presumption and moral reasoning against that because we're worried about the possibility of my saying, "I know better than the owner, I should be entitled to kick out the owner and put it to a higher, better use." But so that's the basis for the right. I haven't yet answered your question, how do you know when activities by other disrupt the right? And so then the problem becomes if the government is discharging water to save coastal area and endangered species, and the discharges have these adverse effects, so then how do you ask the question? There are lots of things that neighbors do to each other that bother them. If every bother is something that a neighbor could complain about, then judges are going to be forced to make these value comparisons you were asking about in your question. And we don't want judges to make these valuable comparisons because judges in practice are nowhere near as wise as King Solomon was. So what you have to do in the law of trespass, the law of nuisance, and in regulations that are modeled on the law of trespass and law of nuisance, you need to develop general rules that then say people are entitled to emit things off of their property as long as what they're emitting off their property doesn't interfere unreasonably with other people's uses. And you don't do this looking at the use of the discharger and the use of the person who's suffering interference. You look more generally at uses that are common in an area. And if the discharges by one person seem grossly out of proportion to the discharges that are unreasonable to uses common in the area, then you say this is a problem. And it's not that you're saying like aesthetic conservation and the other goals that the Corps were preferring are socially better than. It's more the discharges are at a volume that seems out of proportion to the uses typical to the area. And so the government in discharging is saying we're entitled to do our benefits so much we don't care if we disrupt ordinary uses of property all around. And so the focus in the environmental regulation law and the nuisance law is on the disproportionate nature of the discharge, not on the fact that the discharge is helping carry into effect a valuable policy the public likes.
Just to follow up off that, Roof, if you don't mind.
Okay, you get the mic back.
Awesome. So just to go off of that is the reason for the discharge is to get back to a natural level of flooding that is typical before man-made levees and things that have developed over the past century or two in Louisiana. So I'm just curious how do we judge, therefore, that the economic benefits, not just aesthetic, that derive from preserving floodlands and coastal areas from environmental degradation, how are you comparing that with the oyster farmers' profit? I guess that's not clear to me of how you weigh one to the other, how you get to a standard that you can fairly do that.
Again, you're assuming in your question the premise that it's necessary to weigh the economic benefits of the core policy and the economic impact on the oyster growers, and that's a premise I resist. You have different people doing things that are valuable. One of the activities, the river management, to manage the river, one needs to emit discharge that's going to affect lots of other property nearby. And those property owners are entitled to the exclusive use of the resources. The government has legitimate authority to pursue its policies, but in a manner that's respectful of the property rights. And so the way to measure whether the government policy is being carried out in a way that has this disproportionate effect is to ask, are the discharges doing more than seems proportionate, incidental to typical land uses and water uses in the area? And all of this, again, is just trying to abstract from having a government say, I know better that use A is a higher and better use than use B.
Thank you. So along those lines, how would you then evaluate issues of eminent domain? Isn't that a situation where the government is doing precisely that kind of evaluation?
Yeah, and so that's chapters 13, especially 14 of the book. And so, in those cases, private property shall not be taken for a public use without just compensation. So then, you have to establish that one person has private property. And so in Campo, the main questions are whether the oyster growers have property in the oysters or in the leases or both. And then any action that is not a justified police regulation by the government, if it disrupts property rights, that's a taking. Now, if a taking's for public use, then what the government's saying is we do think it necessary for all the purposes that motivated the Corps to discharge. We have to discharge to get the river to its natural level, to conserve species there, to make sure that economic interests that depend on a certain water level can do those. If all of these benefits are benefits that seem likely in practice to disperse to the whole public, then the government has justification to do this. And in those cases, the owner owes a duty to surrender the property the same way that somebody has a duty in a state with a draft to report for the draft. There's sometimes our individual liberties have to be sacrificed for the public good, but since the person had a valid private right that was instituted consistent with natural law, the government needs to own up and say we are disturbing what had been secure property rights, and to keep the balance sheet equal, we need to pay just compensation. So it's like the duty of the person or the exposure of the owner to surrender the property. That's the concession in a system of natural rights to the common good. But the respect for natural rights is made clear by the duty to pay compensation back, and also by the limitation that the taking can only be a taking for public use.
It was great that you mentioned the phrase common good. That was one of the things that I was sort of missing in what you said earlier, that has to come into the picture somehow or other. I'll just leave it at that.
So yeah, since the mic wasn't with the questioner, I'll restate the questioner. The questioner is interested or provoked by the fact that I'd said the common good. And yeah, I left that out of the talk just because of the organization. But remember again, I had said that there's two main families of natural rights theories. Ones that just link natural rights to autonomy, and others that link it to flourishing. So in a system of principles of like a surviving and thriving and moral value. So in those accounts, the way to think about natural rights is they're units in like a political analog to a partnership. So every partner is an agent capable of doing productive things. A partnership is an association that helps coordinate the behavior of the partners so they can all do productive things. In his political system, then, every person is a being capable of surviving and thriving, and has a natural right to try to do things to survive and thrive. but the common good consists of a government and a social community that coordinate every individual's behavior, so everybody's trying to survive and thrive in a way that's respectful of other people's equal opportunities to survive and thrive. So natural rights come to be limited by the common good, but the common good consists of helping the people, the members, pursue their own individual goods and nothing more. Mike first.
Thank you. I have a question, broadly speaking. What's the relationship of natural rights versus the originalist theory of the Constitution?
There's no one answer to that. I think I'm going to restate what I think was kind of the conventional wisdom among jurists like Thomas Rutherford and William Blackstone. And in that provenance, natural law provides an authority for positive law, for Parliament to enact statutes and legislatures to enact statutes, and then for judges to apply basic principles of common law. And it provides a background authority for courts having powers of equity. Now, so then when the natural law provides authority for there being statutes, it's kind of taken for granted or expected that the statutes are meant to secure natural law and natural rights. And so that creates a prima facie obligation to follow the meaning of statutes. But in this tradition, statutes are understood as blunt, crude instruments. And there are cases in which a statute's literal meaning might apply in a way that seems insane in relation to the facts of the case. And so there can be situations in which a judge in this tradition thinks, this statute, though it applies to a concrete set of problems, and we know what those are, and we would give it force as applied to those problems. In this case here, that's not in the set of problems. And in those cases, courts might say the statute we don't think was intended to apply here, or it has an intention, and this case we can effectuate the intention only by applying the statute in a way that doesn't cohere with the literal meaning of the statute. And some originalists find that satisfying, others find that threatening.
Please join me in